number 48, the people of the state of New York versus Edward Hardy. Counsel?
Good afternoon, Your Honors. Ronald Zapata for Appellant Edward Hardy. May I please have 2 minutes for rebuttal?
How many?
May I have 2 minutes?
You may, sir.
Thank you.
You're welcome.
Your Honors, this case presents the issue of whether the prosecution can change the sworn factual allegations of a complainant in a facially in an accusatory instrument to change what would be a facially insufficient instrument into a facially sufficient instrument.
So, counsel, section 115 in the CPL that governs form and content of the accusatory instrument makes no mention of the date of the crime, right? That's what this is about, the date of the crime, correct?
Yes.
Okay, and the legislature has made the provision of the date to defendant part of automatic discovery. Why would the legislature bother to make the date of the crime a product of discovery? How does that fit in with your argument? I'm not following.
Well, the date is the allegation made by the deponent of the accusatory instrument. That is what the reasonable cause...
The date is the what? The allegation?
The date is part of the allegation. The allegation is that the crime occurred on this particular date, and this is the sworn to verified allegation of the complainant in the accusatory instrument. And under the facial sufficiency rules of this court, those allegations must have a reasonable cause to believe that the crime was committed. And here, if
the typo was for an incorrect date that was within the duration of the final order of protection, which is not the case here. Here, the typo had put, it beyond the expiration of the order of protection. But if it was within, would it still be your position that it was still a jurisdictional error?
There would not be a jurisdictional error because the jurisdictional error is the facial sufficiency of the instrument, and that there would still be facial sufficient.
If the date that's alleged is still within the order of protection, a crime is still alleged. It may be wrong. It may be that he's able to prove that he's not guilty, but a crime would still be alleged. I thought part of your argument here was that because the date is beyond the expiration of the order of protection,
well, that's part of it. Yes.
There's no crime alleged, and therefore it's a jurisdictional defect.
Yes, that's part of it. There's two separate analyses here. Is one, can the amendment be made to the factual allegations in the complaint? And the statutory interpretation, the clear language of CPL 100.45, of the legislative history that I've outlined in my briefs, show clearly that the legislature did not allow amendments. Now, the second part of that is, okay, now you look at a facial sufficiency review of the accusatory instrument. And there, if they supposedly had a wrong date, that is the date that they swore to, and therefore it will still be facial.
So why doesn't Easton survive? Why doesn't Easton control? Why are you arguing that common law rule doesn't survive the CPL?
Yes, Easton does not apply because the legislator showed their clear intent to allow amendments only when it comes to informations to change the charges that are made in the accusatory instrument.
Well, I'm not sure why you say that, because as to Superior Court informations, the legislature was clear that you could make an amendment essentially that's consistent with Easton, right? If there's not prejudice to the defendant, you could make the amendment. In section 200.70, isn't there a sentence in there that says, as to Superior Court informations, an amendment may be made of any sort, so long as there's not prejudice?
Well, the amendment, however, the key part with the amendments in the Superior Court information is that it has to have a sworn basis there. The Superior Court information...
Let me ask you this. Are you trying to distinguish between Superior Court informations and misdemeanor complaints as regards to the legislative history or not?
Yeah. And I'll throw in there prosecutor's information.
Well, that's the key here, the prosecutor's informations. What happened here is essentially the prosecutor turned what is the complainant's accusatory instrument into their own instrument by amending the facts of the accusatory instrument. Well, prosecutor's information is under 100.50. A prosecutor's information, you cannot amend, you cannot change the facts of the underlying
But
instrument.
this isn't there's no prosecutor's information involved in this matter, is there?
Well, this is essentially what occurred. By making this amendment to the facts of this officer's sworn allegations, this is now the prosecutor's allegations. So,
Well, no,
like this-
let me be very clear, and it's been a while since I sat in criminal court, but my understanding is that you have the misdemeanor complaint, you have an information, which is what happened here, the court allowed it to be conferred, and the prosecutor's information is something that's typically filed right before you go to trial, and supersedes the information and is much more bare bones and reads much more like a superior court information and/or an indictment. And so prosecutor's information has a very specific meaning, and that's the only one that's actually mentioned in the statute that can be amended. Because at that point, there's already been a determination that there are sufficient non-hearsay allegations that satisfy, all the pleading requirements.
Commissioner, perhaps I'm confusing the issues here. I only mentioned the prosecutor's information as more of a side-by-side to compare. If the legislature was going to allow a prosecutor to amend a misdemeanor complaint or an information, then they would have stated so. Now under 100.50, a prosecutor can file prosecutor's information to supersede the information in a misdemeanor complaint. 100.50 explicitly says that the prosecutor's information has to be based on the information in a misdemeanor complaint. If they aren't allowed to amend the allegations based on their superseding prosecutor's information, it makes no sense to then allow them to amend it for an amended information or misdemeanor complaint.
Counsel, can I ask you something a little bit different? Forfeiture. This is a guilty plea, right?
Yes.
So your argument has to be, so the instrument that the defendant pleads guilty to is the amended instrument. You claim improperly amended, but that's what they plead guilty to. So for your challenge not to be forfeited, this has to be a jurisdictional defect, right?
Yes.
So preservation wouldn't matter, right? So
Yes.
we all agree this is a typographical error.
I don't agree.
You don't agree in your papers is a typographical
Well,
error
this-
that
This is someone's
October
sworn
versus
testimony.
January?
We don't know if this is just an unreliable person.
Okay, you don't agree
We
it's
can't just
typographical
make
error.
these assumptions.
But if anything in Easton survives, I mean, let's say your argument for the sake of right now purposes is correct and the civil procedure law changed, it seems to me the core holding of Easton that you don't enthrone this type of error, enthrone their word, as a jurisdictional defect would still be true. Because the argument, it seems to me, that prevailed in county court in Easton was this argument, that this is a jurisdictional defect under the criminal procedure rules of the time. And this court said, no, you can amend. Now, assuming you can't amend, I think under the new rule, I think the old case law, Easton, would still stand for the proposition that this type of a switch of dates under these circumstances, call it what you want, is not a jurisdictional error.
Well, here's what a jurisdictional error would be. It's, does the accuser instrument allege a crime? A crime in the future is not a crime.
But it does
People
allege a
can
crime.
In the
It alleges a
future,
crime.
that's
The
impossible.
document your client pled to alleged a crime. Your claim isn't the document my client pled to doesn't allege a crime. Your claim is it was improperly amended. And to get to that underneath the face of the document your client pled to, that has to be a jurisdictional error.
I would disagree based on this court's decision in People v. Harper. In Harper, interpreting the same statute 100.45 to amend, this court stated that the amendment, since it was improper under that statute, it could not be effective, and therefore the accuser instrument must be evaluated based on how it was without the amendment. It's the same situation
What was the
here.
amendment in Harper?
I'm sorry?
What was the amendment in Harper?
The amendment was to add a couple of charges.
Right. But you see a difference between adding charges and changing a date that's impossible, which would have been a transposed numerical date.
But there has to be some basis to change the date within the four corners.
What you're saying is there should have been an affiant to testify to that date, and there wasn't, as to
Yes,
the, as
sure.
to the amended indictment.
Yes.
That's why you say it's jurisdictional?
Yes, this is why we have verification requirements and sworn requirements and the reasonable cause requirements.
So let me ask this. Would your theory allow for a distinction between a factual amendment, which you say this is, and a technical or typographical, an obvious typographical error?
No,
In
amendments
other
are not
words,
permitted.
let me just finish, just so I'm clear. So in other words, any error at all as to the form that it cannot be viewed by the court in any other way except as a factual error, even if, as Judge Garcia was saying, this seems to be an obvious typographical error.
Well, there has to be a basis to change it, though. What's the basis to change it? It's all about assumptions from the person.
Well, I suppose a factual error would be to conform the pleadings to the proof. A technical error would be you put an S at the end of a word and it was obviously singular, and so it was a person instead of persons, as an example. So therefore, we're not going to throw out an accusatory instrument as containing a jurisdictional defect because of that kind of an error. Your argument would be that we would have to throw that out.
I'm sorry, so what would be the example?
The argument is a minor typographical error. Say you pluralize a word. Instead of calling someone a person, you call them a persons, and you use the S at the end of the word. That would create a situation where there would be a factual error that appears to be an obvious typographical error that the court could not ignore, and under the ruling that you're asking for, we would have to throw the case out.
Well, it would be under this court's facial sufficiency rule.
No, I'm asking you, is that correct? Would you agree with that?
Well, if this court under facial sufficiency, a review, this court can consider whether it believes something is a typo or not. But there has to be a sworn basis to replace what is in the complaint.
Well, I thought your argument was, in response to Fahey, based on what you wrote, would be that changing persons to person may not,
It may
in
not be
fact,
amended.
mean it's deficient of an element of the crime. Whereas here you're saying the date makes it impossible.
Yes,
And so
exactly.
therefore you don't have an element of the crime. I thought that was the
Yes,
argument
no.
that you were trying to make. But either way, whether we agree with you on the jurisdiction, that it's jurisdictional or not, the reality is we have to resolve this question to figure out whether it's jurisdictional or not, correct? So either way, we're going to get to your argument. Is that not correct?
You mean a facial sufficiency of the...
Well, the question whether or not you can make the amendment.
Yes, well...
I mean, don't you have to resolve that?
Yes, exactly.
Either way?
Yes, because you can't do unauthorized actions to make an instrument gain jurisdiction over an instrument. You can't, for instance, the prosecutor can't forge a signature of a complainant who didn't sign it. A court in Albany can't pretend they're a court in Manhattan to gain jurisdiction over a Manhattan crime. You can't do unauthorized actions to gain jurisdiction over an action.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court. Mariana Zeller from Queens County DA's office of Melinda Katz. Defendant's reading of the statute, specifically 100.45, is simply unworkable, and it's simply wrong.
Counsel, in court, before the plea, the ADA realized that there was a problem and moved to amend. Why would the ADA move to amend if they didn't think that the accusatory instrument was legally insufficient?
Well, the issue is the instrument was sufficient, but if the court is allowed to amend, which the statute permits.
So wait a minute.
based
Are you
upon-
saying it was sufficient,
Oh, I'm sorry.
over here, are you saying that it was sufficient before the amendment?
No, it was insufficient before the amendment.
Okay, so you would
I
concede
would
that. So in
concede
other
that.
words, let's say the court hadn't interrupted and hadn't said anything, all right? And defense counsel was making his point, and he said, Judge, I'm moving to dismiss because there's no crime alleged here. October whatever hasn't come, and it's beyond the expiration of the order of protection. The order of protection expired in September, and the date of the crime is alleged to be in October.
Correct. And then what
You would
happen-
agree that that complaint would be insufficient?
Well, yes, and if the defendant made a motion to dismiss, then what kicks in is CPL 17035, which says that on a motion to dismiss, prior to the court dismissing it, it must, the statute specifically says it must cure the deficiency if it can do so by an amendment.
But doesn't that assume that there is a basis for making the amendment?
Of course, I mean.
Oh,
if-
okay, so
yeah.
if neither the CPL nor any common law rules permit the amendment of this instrument, then 17035 is just not applicable, right?
No, I think you have to read them together, Your Honor. The way it works, according to the
So
statute.
you're saying that 17035 adds grounds to make an amendment so that anything that is, that there's a jurisdictional deficiency, now all of a sudden, even though the CPL doesn't say anything about permitting amendments of this in the first place, now includes anything and
No.
everything?
No, Your Honor. Under the praxis commentaries of 17035, it talks about non-jurisdictional amendments. So of course, if it's a jurisdictional defect, the people are not arguing that we can amend a jurisdictional defect, and those rights are not forfeited, and they do not have to be preserved. But our argument in this particular case is, was the court permitted to make the amendment? And CPL 145 does not prohibit that, and the defendant's reading of it is simply wrong. Statutory interpretation.
Well, but it doesn't expressly allow for it. You know, how do you respond to the legislative history that the defendant pointed out in his reference to the Bartlett Commission under 17035? That seems to clearly support their argument.
Support my argument.
No, I think it supports their argument.
Well, actually, no, Your Honor, it supports the people's argument. I'll tell you why, because
Sure.
The 1968 study bill, which had initially had the 145, including amendments made to prosecutors' information, I'm sorry, not prosecutors' information, misdemeanor complaints and information. So defendant's argument is that they took that out, which means they didn't intend to allow amendments. However, if you look at 17035, the 1968 study bill, that also included that amendments could be made subject to 145, or the old CPL, or the old Code 5035. And they took that out in the final 1970s CPL draft. So if you look at both of those together, clearly they didn't intend to limit amendments to...
Well, this is one of those arguments, those expressio unis arguments. The legislature knew what they were doing. If they wanted to do that, they would have done it. They didn't do it.
They didn't do it. And the fact, if they wanted to put a prohibition to make an amendment, something simple as this, first of all, the issue really becomes mistakes are made. It's
So,
normal
no, let me
for
just stay,
mistakes
let's
to
slow
be-
down.
Sure.
Let's just stay on this point for a second.
Sure.
Are you saying to me that, in your view, the provisions of CPL 200.70 do apply to information and misdemeanor complaints?
No, they only apply to prosecutors'
I
information.
see.
Everything else,
And
That's
and superior
non-jurisdictional.
court informations as well.
Right. Yes.
and not only that, Your Honor, further support for our position is noted that the fact that form and substance facial sufficiency for prosecutors' information is pursuant to 135, whereas form and substance as to misdemeanor complaints and informations is under 100.40. So there's different structures for those documents, which is the reason you have to look at the statutory language where it's specifically limited that CPL 270, which applies to indictments, only applies to prosecutors' informations because prosecutors' informations are usually the product of a grand jury. So they're very similar documents.
Sometimes we apply the principle that we as the court should not add something to a statute that isn't there, even though we think maybe the legislature intended it to be there. Why shouldn't we let the legislature either act or not act. Why shouldn't we say in this case that it's not there? And so if the legislature wants it to be there, then they should act. Why shouldn't that be our determination?
Because the reverse is true, Your Honor. We could also equally say that the fact that it doesn't prohibit it means it's not prohibited. The fact we should not read more into the statute than simply CPL 270 applies to prosecutors' information, nothing more, nothing less. Anything that's related to misdemeanor complaints or informations, if it's non-jurisdictional, it's subject to amendment, and upon motion to dismiss by the defendant, CPL 17035 enables the court to make the amendment.
Well, except that you could read CPL 200.70 as applying to indictments and superior court informations and prosecutors' informations, and stating the way that those things, and perhaps only those things, can be amended. There's no authorization in the CPL for any sort of other amendment, and at least a possible policy explanation is the following. All the types that can be amended that are specified in the CPL are ones that are instituted either by a grand jury or by a prosecutor as an officer of the court. The misdemeanor complaints and the regular informations can be instituted, by an affiant who could be anybody.
Well,
and in those circumstances, we want the affiant back if there has to be an amendment to something important.
And I would add to that observation, though, that the Superior Court information requires a waiver from the defendant, when it's filed. You can't just file a Superior Court information. You have the felony complaint, and then that's typically a negotiation between the defense and the prosecution to proceed by SCI rather than go forward with a grand jury presentation.
But again, you're speaking about indictments. You're talking about prosecutors' informations. It's a different facial sufficiency standard. It's a different form. Applies to a different statute. It's 135.
Which is also perhaps why it's treated differently.
Exactly.
I mean, misdemeanor complaints and misdemeanor informations, there's no testing of the factual allegations by a grand jury.
The issue is that a prosecutor's information, if it's normally the product of a grand jury, therefore it's subject to the same limitations. The DA can't change something because a prima facie case has already been established by the grand jury. But a misdemeanor complaint, especially in this particular case where you have the domestic incident report, that allows it to be a supporting deposition, and according to CPL 100.
Let me ask you this question. What if the court had not intervened, the defendant made his motion, and perhaps the defendant, the people responded, we want that motion in writing. That's what used to happen all the time. People would point out various insufficiencies. You put it over, and in the meantime, the prosecution is then free to file a superseding accusatory instrument. Isn't that really what should have happened here?
And certainly could have happened if the defendant had preserved that issue, but instead...
Well, wasn't he cut off by the court?
He was, and then he didn't have to take the plea. He could have said, I move to dismiss, or he could have said, I have to approve, you have to dismiss the complaint. And then what would have happened? They would have rearrested the defendant, and then I don't think the defendant would have wanted something like that. They would have dismissed the complaint.
Well, I don't know that the court would have dismissed it. In my experience, two things happen. One, the court puts it over for the file of, I don't know how this term came to be used, a superseder, or if the court does actually grant it, and I concede it's different here because this is a DV case, very often those cases just went away, never came back. Because in the exercise of the discretion, the prosecutor's office would often say, you know what, just let it go.
Counsel, I see your red light went off, so I just have a question, just for clarification. Is it your position that the appellate term was right in its view of 170.35 that it sets out in footnote 3 of the appellate term's decision?
Correct. And
That this language is of a kind that may be cured by amendment. Is the legislature also recognizing that the Easton rule was in place at the time and so was adopting that, adopting this language with the understanding that that rule was in place?
Correct.
Right. Is there anything else other than that reading that one might gloss on that supports that particular view?
Well, as I indicated, the plain language does not specifically prohibit it. And the legislature's enactment of 17035 would negate their intent to prevent these type of non-jurisdictional simple amendments. Otherwise, you'd be clogging up the system. You're talking about misdemeanor court where there's thousands of cases being disposed of, quickly. The defendant in this particular case immediately...
But the rule is a narrow one, right? I mean, the rule is a narrow one. There has to be no prejudice to the defendant.
No surprise.
It has to be obvious on its face,
Yes.
despite, I understand the position of defense counsel here about this date, but there are other indicia
Of course.
of that it is a typo.
Thank you, Your Honor, exactly.
Well, but is there a difference between, for example, let's say a typo said gum, G-U-M, instead of gun, G-U-N, and one of this nature where you have a date that clearly couldn't be correct, but then you don't know what the correct date is? Is there a difference between those two types of typographical errors?
Well, I wouldn't say, I couldn't say there's a difference, because on those facts, the difference is, yes, gum and gun is a typographical error, but in this particular case, we have the supporting deposition of the DIR, which has the date. The prosecutor wasn't getting the date.
Yeah, but
as-
those
Well, you would
dates were all
concede
messed
that
up.
DIR is full of all sorts of errors. It's got the wrong year, it doesn't have the signature of the complaining witness, is my recollection.
It does on the second page, it has the same.
Yeah, but I thought she didn't,
The date was wrong.
the
They
date was
stated-
wrong, right.
But it was January, it was right after, the new year, which is common. And the CPL doesn't require the date on the verification.
Yeah,
It
well, the
just
whole,
requires-
the whole issue of whether the DIR can actually be used is, I don't know if that's actually ever made it here.
That's not an issue before the court.
Yeah, I know it's not before the court, but I know it's been the subject of debate.
I mean, if I may, Your Honor, just for a moment, our position is that if the legislature had intended to prohibit, they would have. And if you just rely on the fact that the history of the study bills show that it was originally in 145 as to the prior amendment, then equally look at the study bill of 17035, where it was similarly in the original study bill. And you have to look at the fact that what's the legislature's intent in enacting the CPL? It was to simplify things. Just like a verified information, you didn't have to go to court to sign it before court. You were able to do it with the short form, with the jurat at the bottom. So it doesn't make sense that they would have abrogated Easton, and it's limited to the specific instances.
Except that they did, try to get away from having to have the police officer constantly be in the courtroom to verify these things in front of the judge and all of that. But the flip side of that is, doesn't that make it more important for the affiant's statements under oath to be accurate and to actually allege a crime?
Absolutely, absolutely, Your Honor. And they
their
did
written
allege a crime
statements.
here. They did the affidavit was facially sufficient. Once the court amended the date, it was a facially sufficient affidavit, and the court had jurisdiction to accept the plea.
Thank you, counsel.
Thank you,
Counsel?
Your Honor.
All right, let's talk about Easton for a little bit. Why did Easton allow the amendment there? One, the complainant was there and actually presented sworn testimony about the change of date. Two, Easton, their basis was on the common law, and the common law said that informations are as declarations in the king's suit. An officer of the crown has the right of framing them originally. He may amend in like manner as any plaintiff may. So under Easton, every single information is brought by the prosecutor. The prosecutor can change anything they want in there because they are doing it under the king's suit. The CPL knocks the crown off of the prosecutor's head because they provided different types of instruments instead of this one information that was only brought by under the king's suit. They brought the misdemeanor complaint. They brought the information. These are both have to be sworn to and verified by a different plaintiff. The only accuser instrument that could be brought by the prosecutor in the CPL now was a prosecutor's information. And under the CPL, a prosecutor's information can only be
Go
brought.
back
But
to
what
your
about her
point.
point? It's just not workable. Sort of what would the world be under your rule? Well, how would this have played out, and how will it play out in the many other cases? She's correct. People are human, they make mistakes. We don't like them, but people make those kinds of mistakes. The question is whether or not they prejudice the defendant and whether or not they're of the kind that we should be concerned about. What would your rule work like day to day in these courts?
Well, it's absolutely workable because the legislature provided the opportunity to file a superseding information. All the people had to do was if it was an actual mistake, get the complainant to do a superseding information. This is the protections that the legislature provided.
These problems, these city court problems, Judge Feynman said in city court, and Judge Stein did, I did, and they're volume problems. As you know, if you've done this stuff, and the amount of volume that a city court deals with in a city like New York is onerous, and so things are moved along. I think that's what we're confronting here, that people look at this as a de minimis change, and why isn't this within the purview of the court in a murky legislative history setting for us to have the law reach out and correct this?
Well, one, I would argue it's not murky, but what is there?
Well, let's assume that my statement's correct.
Okay.
Okay.
So if you're saying
for today, anyway.
Okay. So
Go ahead.
You're saying, okay, because the legislature did not
Because we're in a fungible area, because we're in an area where a reasonable person could say, well, what's the point of bringing this person in? This guy's going to plea anyway. And since he's going to plea, why do we have to go through all that? Why not just let's fix this typographical error? That's also a factual error. I'm not diminishing that, and resolve this question now. How is an injustice done by doing that? I guess that's my question to you.
The injustice is that the defendant is entitled to all the protections that the legislature has provided
Right.
them.
I agree with that.
Yes.
I agree with you. Frankly, they're sacred. But how is an injustice done in this setting if the person's about to plea and you're correcting a typographical error?
Well, this also changes the dynamic of the plea negotiation process. Look at what happens here. The defendant sees that the prosecutor can just change the allegations from the complainant to allege a sufficient crime rather than force them to do anything else.
But isn't that concern addressed with, as I was mentioning to the ADA, the narrowness of the rule? That this is only when it's an obvious typo, there's no prejudice to the defendant, and that way you've reached some balance between the rights of the defendant and what our system should be concerned about, and as Judge Fahey is pointing out, the demands on the judges, on the judicial system.
Yes, but how does this protect against the unreliable complainant? How does this protect against a complainant who is careless and doesn't care and it would not follow through on anything? This is the protections that the legislature has provided to the defendant. It has to be sworn factual allegations, and if it's not met, then the
But that's what I'm saying. There is indicia of reliability that this really is a typo. I get your point when perhaps it is not so obvious. I understand that. That's what I'm saying about the narrowness of the rule.
If Easton survives, you're not claiming there's any prejudice or surprise to Mr. Hardy, is that right?
No, but notice is not the only reason that we have to accuse our instruments.
No, I'm just asking, if we were to hold that Easton has survived, you're not saying it needs to go back for determination of prejudice or anything like that. You're conceding that there's not prejudice here.
No.
No means, I'm sorry, it means yes, you're conceding that, or?
Yes,
Okay.
there's no prejudice. Yeah.
Thank you, counsel.
Thank you.